Testing, testing. Alright, year 2023 Connecticut General Statutes titled 16A Planning Energy Policy, Chapter 296 Operation Fuel Supply Business. Section 16A, sub on the definitions. Used within Section 1618 within 1620, inclusive of the creating of fuel storage for me with a diminution and conveyance of the artificial means of the supply of fuel to a point below the need of the meat consumer demands adequately, and fuel includes the coal products, electricity, natural gas, petroleum products, radioactive material, wood fuels, any other resource yielding energy, be as used in Section 16A 21, 16A 22A, and 16A 22K. Associated equipment means gas line, gas regulator, sacrificial anoid, interconnecting hardware, any other of the equipment that is necessary to install with the operator propane tank. Automatic delivery means with the delivery heating fuel to a consumer by dealer under a system determined by the dealer consumer. Calculating consumer heating fuel needs based on the consumer heating fuel consumption. Cash A means with a certified cashier check. Commercial money order legal tender equivalent such check with a money order legal tender, but include the guaranteed payment on the behalf of the consumer by a government unity action agency provided no discount is taken with the charges bill. Commissioner means with the commissioner of the consumer protection. Consumer means a direct purchase of the heating and fuel from the heating dealer with one or more of the dwelling units within the structure have no more than 4 dwelling units. Gallon means acceptable unit with a unit measuring consisting of 231 cubic inches for a liquid and gaseous heating fuel, subject to the modification allowed with the under regulation adopted pursuant to Section 4342. 7. Heating fuel means with a petroleum-based fuel with included petroleum product related with the pursuant with Chapter 250 for the use of the primary source of the residential heating and residential heating and domestic hot water. Heating fuel deal with the dealer means an individual group of the individuals who are of the cooperative with a corporation firm and a limited liability company partnership that offers to sell the retail of the heating fuel to a consumer. A lesser means of a natural person who rents a lease of the personal property under consumer rental lease agreement. Leaser means a heating dealer who the regulator provides use on personal property through the consumer rental with the lease agreements and the rent is paid with a fixed interval with use of such property. 11. Notice of the termination automatic delivery means with the notice of the consumer that the dealer providing automatic delivery in which the consumer requires the dealer terminate with its automatic delivery. And 12. Purchase price with the commercial responsible principal price if it does not include fair market value propane tank associated equipment as applicable. Then we'll leave the history and we'll go to the next one. Alright, 16A18, illegal creation of fuel shortages penalty extradition. No person or firm, corporation, business with a combination thereof shall with an individually perform any act of the conspired to perform any act with the act that creates a shortage of fuel, probably shortage of fuel in this state with which intent with a raised fuel price with the energy price adversely affect the competition in the state within way with the violate antitrust laws of the state with the Connecticut other laws in which the state regulating illegal business practice with any person, firm, corporation, business combination thereof of the violating provisions subsection A of the section should be guilty with a Class G felony, except if the person should be fined no more than $250,000. And if any person violates Section 16A 17 through 16A 20, inclusive of subsequently leave the jurisdiction of the state with the Chief's Attorney General, shall seek extradition of such individual if an individual violates any provision said section physically present with another state with the Chief State Attorney with a designee shall seek with the extradition of said individual under like a provision of Section 162 Uniform Criminal Extradition Act as it may appear with the other jurisdiction under any other applicable law or such other jurisdiction. Alright, 1619 Powers of Investigation section is repealed. 1618-19 is repealed. 1620 Enforcement Civil Act and Privilege Damage Reciprocity. The Department of Energy for the Environmental Protection may institute civil action within the Superior Court and with the United States with the District of the where applicable against the person, firm, corporation, business with the combination thereof believes his reason believe that violates Section 16A 17 through 16A 20 with the inclusive of the enjoined authority for the continuing such conduct with the shade of the seek of the repayment of the damage on behalf of the individual business with the industries harmed by the said activities and such actions shall be represented by the Attorney General. Upon institution civil action, Attorney General shall have the right to take the disposition any of the witness. Attorney General believe they have the reason to believe the information relative to the prosecution of such action. Upon application made by the Supreme Court, nothing would stand with the provision of the other statute limited to the deposition of the Attorney General shall also have the right to such the dispositions in the state to utilize law of such other statutes for the relative to taking the disposition were allowed by laws of the such state. State of the Connecticut shall allow similar dispositions to be taken with the state of the behalf of the governmental agency with another state, any other territory with the possession of the United States taken with the purse. Sue litigator similar to the permitted under Section 16A17 through 16A20 with the inclusive as long as the state allowed with the Attorney General to take dispositions for which within jurisdiction and so doing so the Supreme Court shall enforce orders of the courts of the other states relative to the disposition requested, issue subpoenas with the other subpoena with the deuce of the rectum necessary as well with the enforcing such subpoenas through citation, contempt with the other available remedies. C. In any case of the damages referred in subsection A of the section shall be proven with a fair preponderance of the evidence of the court shall order repayment by any only substance defendants and said damage of the applicable parties of the business through the Department of Energy and Environmental Protection. The court shall have the right in the discretion and acts if the tradable damage of it against said defendants. D. Any such civil action shall be privileged in assignment for trial. Alright, 16A21, heating deal for fuel dealers seeing sale of heating fuel, renting or leasing of the heating fuel tank contract requirement surcharge prohibited, exemption consumer right to cancel regulations and penalties. Alright, A1, no heating fuel dealer shall heat the fuel with the rent with a lease heat fuel tank without written contract with the contained with a term of the condition of the delivery such heating with the amount of fuel for the charge for the surcharge the penalties allowed with the under the section. Except for the consumer under such contract, no such contract containing any fee for the charge for the subcharge of the penalty for the except for the allowed for the pursuant in subsection E, F, and G of this section. The tank fuel rentals of the liquidated damage of the violation of the contract term of the no contract delivering heating of the fuel of the under subsection shall include provisions of the liquidated damages for consumer breach of the source of the contract, whether the liquidated damage of the actual damage of the heating fuel deal with the cause by such breach. No written contract period of the heating fuel shall be for a firm greater than 36 months. Each heating fuel dealer shall offer for the consumer the option to enter for the bona fide commercial with a reasonable contract with a term of 18 months with the consumer, and a heating fuel dealer may agree to enter in a bona fide commercial responsible contract with a term less than 18 months longer. Fuel contract term lengths may be permitted to underground tank consumers provide fuel term and agreements concurrent with the tank leasing agreement specified in subdivision 2 of the subsection. No provision of the contract restrict the consumer ability to utilize another propane fuel provider shall provide valid, and enforceable unless the consumer has initiated clearly conspicuous statement in all capital letters no less than 12-point bold-faced type indicating that the consumer is aware of such restriction. 2. If the tank is being leased with a lend to the consumer, contract with the tank of rental with a loan shall indicate with the writing the description of the tank of the initial installation charge of the tank amount of the time of the rental over the loan payment of manner with which the lessor will create the leaser for any unused heating with the terms of the leaser and with the terminate with a contract with the lessor may enter with a separate contract with the leaser with additional services included but not limited to the maintenance, repair, warranty with the requirement equipment period of such contract comply with the provision of the subsection. No contracted tankers installed above the ground shall be term greater for the 36 months, but the consumer shall have given the option to enter the bona fide commercial reasonable contract with a term of 18 months. A leaser and a lessor may agree to enter for the bona fide commercial responsible contract term lesser than 18 months, and all the contract with the term installed with underground shall exceed 5 years. 3A. If the tank is installed with underground, provide with the consumer the contract such tank containing the clause providing with the consumer the option to purchase for the tank and associated equipment at a price that not exceed with the commercial reasonable price at any time within the length of the contract with the purchase for the tank shall be disclosed, and when the contract shall not increase with before the contract expire without any waiver liability transfer of the warranty shall be stated within the contract. No contract such tanks shall be valid and enforceable unless the consumer that is initiated clear with a conspicuous statement in all capital letters no less than 12-point bold faces indicating that the consumer aware of such option purchase for tank associated equipment for existing contracts, whether the oral, written, whether the purchase option purchase price is silent, unspecified with the contract addendum included with the purchase option with a commercial reasonable price shall be made mailed delivered to the consumer no later than September 1st, 2013. Should the contract addendum should contain with the providing the leaser with the option with the purchasing of the tank associated with equipment at any time on the September 1st, 2018, upon purchase of the tank of the associated equipment, any existing contracts pursuant with the subdivision 1 and 2 of this subsection shall terminate immediately, except with a guaranteed price pursuant with Chapter 6.296A. B. If the tank shall be above ground is provided with the consumer of the contract, such tank shall contain the clause provided with the consumer that the option purchase of the new tank with associated equipment is a price not exceeding commercial reasonable price any time during the length of the contract purchase to a price of the tank of the associated equipment. Associated installation charges shall be discovered within the contract, not increased by before the contract size of the waiver liability transfer of the warranty shall be stated in the contract. No contract such change shall be valid and enforceable unless the consumer has initiated clear conspicuous statement, all capital letters no less than 12 point boldface, indicating that the consumer is aware of such purpose of the purchase for the new tank associated equipment. Upon purchase of the tank and any associated equipment, existing contract obligations pursuant with subdivision 1 and 2 of the subsection shall be terminated immediately, except for guaranteed price pursuant in Chapter 296A. 4. The contract required in this section shall be written and shall comply with the plain language requirements section 42.152 with the provided any fee for the charges, surcharge, penalty disclosed in the such contract shall be in 12 point boldface type with a uniform font with a fee for the charge for the penalty should not include the prior to the expiration of the contract. 5. A written contract with the sale, hearing, fuel, with the lease of the equipment calls for the automatic renewal of the contract not valid unless the contract comply with the provision of the section 14.126B with the Chapter 296A, but the requirement of the contract written pursuant with the section shall not apply with any of the heating fuels delivery indicating consumer payable to delivery bill to the consumer with no future delivery commitment with no fee with the charge surcharge with the penalty is assessed except for the fee and charge surcharge authorized by under subsection G of the section. 7. The requirement of the contract writing pursuant to this section shall not apply with the agreements of the solely with the automatic delivery. A. With the consumer the term of the automatic delivery at any time with no fee, charge, surcharge, penalty assumed with the termination. B. With the dealer provide with the automatic delivery, provide with the written notice of the consumer the delivery serves the automatic delivery met for the termination. Automatic delivery is specified in the subdivision. Such written notice shall include within each invoice products that to automatic delivery notice for the consumer to the dealer requesting termination. Automatic delivery made delivered to the dealer by a written request for the consumer delivered certified mail to the dealer. Electronic mail sent from the consumer to the valid electronic mail address dealer. With 3. The electronic fastenable with the consumer to be sent with a valid fastenable number to the dealer place of business. Consumer shall be given at least notice 1 day prior to the day upon which the consumer desires to terminate automatic delivery. The consumer shall not be responsible for the payment deliveries by the day either such notice has been given except for the deliveries within 1 business notice if the notice has been given which were scheduled for the delivery dealer prior to such notice be given the provided with the consideration should be given in weekend holiday closing extenuation circumstances not under the control of the dealer. P. If the consumer complaint be mediated and investigated by the Commissioner, heating fuel dealer owners of the tank and exclusive filling rights may not deny the consumer deliveries heating fuel for the fueling for cooking, power generation because of the existence of the meditation of investigation provided the heating fuel dealer remains an exclusive supplier of such fuel for the consumer pay cash for such fuel upon delivery. C. For the requirement of the contract written set forth the section satisfied with the pursuant with the provision of Connecticut Uniform Electronic Transaction Act section 1266 through 1286 inclusive section 2 section 42A7 and 101 to 42A7 and 106 inclusive 3 Electronic Signature Global National Commercial Act Title 15 U.S. Standard Code 701 intent sequence as provided in subsection D, but then the verbal telephone communication not satisfying written requirement of the section D. The requirement of the contract written pursuant to section 16A 23N may be satisfied telephonically only with a heating fuel dealer. 1 has provided the consumer prior to the telephonic communication all term condition and contract written except for the contract duration, unit practices, maximum number of dealers, unit covered by the contract employee with the interactive voice for the respond with the similar technology provided for the consumer with the contract duration, unit price, maximum number of units covered in the contract. 3 retains a period of less than 1 year with the date of the expiration contract, readily retrievable format recording of the consumer affirmation, such terms and conditions. 4 send to the consumer a letter conforming the consumer agreement, such terms and conditions such as written common determined condition agreed to. For the 5 of them retains a copy of such letter No heating fuel dealer shall deliver heating fuel without placing the unit and price clearly indicated in such for the total number of gallons used sold with the amount of the fee of the charge surcharge allowed pursuant to the section. Choose play for the delivery ticket given to the consumer the agent of the consumer the time of delivery and over the heating dealer shall be billed with the otherwise attempt with the cut for a form consumer heating fuel the amount exceeded the unit price by multiplied by the total number of gallons used and state with the delivery ticket plus the annual with the amount of fee charge surcharge allowed pursuant to the section state with the delivery ticket. After no heating dealer shall accept the fee of the charge of any of the delivery included, not limited to any delivery under automatic delivery agreement and issue with the dealer to consumer. G. No heating fuel dealer shall assess fee of the charge within the price per gallon tank delivery charge for any heating fuel dealer initiated of the consumer except when one heating fuel dealer is less than 100 gallons. Heating fuel delivery is outside of the normal service area of the dealer. Heating fuel dealer is made out of the normal business hours of the dealer. Dealer incurs extraordinary labor costs heating delivery. Alright, except for the underground tank and addendum will require pursuant to subdivision 3, subsection A of the section. Provisions of the section shall not apply with existing consumers to a heating dealer of the July 2013 who had valid written contracts on 7th date, but the provisions section shall apply with the renewal expiration dates of the contract. A consumer shall have the right to cancel for the relation for the heating fuel dealer without penalty with the above ground tank with the land with the lease for the relation for the problem with the oil agreement accord for the dealing no tank removal the charge of the forfeiture. Unused heating fuel shall be permitted for the consumer cancel for the section such as the per relation for the consumer shall be entitled to perform with the unused heating fuel same price for the consumer purchase such heating fuel. The Consumer Protection and Adapt the regulation pursuant to the Chapter 54 of the Established Consumer the Bill of the Rights regarding home heating dealers for the required for the heating fuel dealer to provide consumers for the Consumer the Bill of Rights to enter into Contract 3 permit home heating dealers to post consumer rights on bills for the right for the internet website of the record playback consumer the Bill of Rights consumer call for the officer of the heating fuel dealers. K. A violation provision section shall be unfair trade price for the subsection A, section 42.110b, and L. Any heating fuel dealer who violates provisions of the section with more than $500 for the first offense, no more than $750 for the second offense, including no more than 3 years after the prior offense, no more than $1,500 in the third and subsequent offense occurring with no more than 3 years after the prior offense. Alright, 16A, 21A, sulfur content home heating oil, off-road diesel fuel suspension requirements for the emergency enforcement. A1, the amount of sulfur the content of the fuel cell offered for the sale of the distributed to the savings will not exceed the following percentage of the by weight for normal 2 heating oil with the 3/10 of the 1% with the beef for the number 2 off-road diesel with the 3/10 of the 1%. 2, notwithstanding subdivision 1 subsection with the amount of sulfur content, number 2 heating oil sold with the offer shell with the distributed to the savings not exceed with the following percentage by weight. A, for the period being July 1st to 2014, ending in June 13, 2018, 500 parts per million. B, on and after July 1st to 2018, 15 parts per million. The Commissioner of Energy Environmental Protection may suspend with the requirement subsection A of this section with the Commissioner found with the physical availability of the fuel comply with the requirements that are inadequate to meet with the needs of the residential, commercial, industrial users within the state. Such inadequate physical advisability constitute with the emergency provided with the consumer commissioner shall comply, specify with a written period of the time such for the suspension shall be in effect. Commissioner of Energy Environmental Protection may enforce the provisions subsection A and B with the section utilizing methodology sections standards specified in the 22A 174 19B regulation of Connecticut state agencies. Alright, 16A 21B low carbon fuel blend requirement heating oil restriction effective with the day's provision staying with a temporary waiver for the requirement regulation. For the purpose of the section A1 heating oil the means of the fuel American Society Testing Materials ASTM standard with the D396 over the ASTM standard D67 and 51 low carbon fuel blend meet with the fuel meeting with a standard with the advanced biofuel with the under the federal renewable fuel standard program requiring 50% of the reduction in the life cycle of the greenhouse gas emission included but not limited to qualified biodiesel meeting with the most recent version of ASTM and international designation D6751 and solid mean for the wholesale with the made with the retail sale made end user consumer. So for the provision in subsection D of the section 1 no later than July 1st 2022 all heating oil stable with a lower carbon containment not less than 5% biodiesel for the trend not later than July 1st, 2025. The heating of the oil sold with the shape of the shall be with the low carbon fuel blend with not less than 10% of the biodiesel, and 3, no later than July 1st, 2030. All heating oil sold with the shape shall be the low carbon fuel blend containing not less than 15% biodiesel fuel, and 4, no later than July 1st, 2034. All heating oil sold within the shapes of the low carbon fuel blend containing no less than 25% biodiesel. 5, no later than July 1st, 2035. All heating oil sold within the shapes of the low carbon fuel with blended containing not less than 50% biodiesel fuel. See the list of the Commissioner of Energy and Environmental Protection waiver the requirements of subsection B of this section, and owners pursuant with the subsection D of this section. Low carbon fuel blend heating oil shall produce according to industrial accept the quality standards and certified analysis verified for information critical specification designation of the D6751 ASCM International defined with the National Biodiesel Accreditation Program. Other applicable ASCM specification low carbon fuel blends shall be provided with the marketers of the produce a low carbon fuel prior to the blending of such low carbon fuel with the heating oil. D. The Commissioner of Energy Environmental Protection may temporarily waive the requirements of subsection B of the section Commissioner determines at any time when the shape of the requirements is not feasible to do with the lack of the adequate supply of biodiesel would result in a financial hardship to the consumers. No later than July 1st, 2022, the Commissioner of Energy and Environmental Protection may adopt regulations in accordance with Chapter 54 concerning the requirements of the heat retailer heating oil with the disclosure of the percentage low carbon fuel blend contained in the home heating delivery consumer with the approximate range of such percentage. R16A21C Heating Oil and Oil Feedstock Company Petition Environmental Protection Agency, Department of Energy Environmental Protection Assistance. Department of Energy Environmental Protection in consultation with the Department of Agriculture Management for the one more of the company's submission for the petition with the Environmental Protection Agency that approve of the cap of the oil as of the feedstock and the fuel pathway with the heating oil program with renewable fuel standard programs such as the assistance may include shall not be limited to inquiring status kept and kelp oil consideration feedstock with the Heating Oil Environmental Protection Agency. Such program provided with any applicable with requisite information the Department for the may support with such petition facilitating timely communications between the Environmental Protection Agency of the relevant state agencies and any other such petition company and then further ends of any such petition. Alright, 16A22 and 22. Notice the wholesaler impending shortage termination supply of petroleum products non-discrimination penalty. Any person with engaged for the business of selling the petroleum product defined in Section 16A22C with a wholesale basis with sufficient knowledge of the impending shortage of the availability of the petroleum product defined in Section 16A22C, officer or manager of a firm of the corporation engaged within such a business, such knowledge of the child of the case, for the be given an immediate written notice of the possibility and inability to resolve the term of the storage delivery of petroleum products, and is defined in Section 16A22C. Commissioner of Energy Environmental Protection to each of the retail dealer and oil dealer engaged in the business supplying petroleum products defined in 16A22C. Residential heating such version for the corporation customarily supplied with the petroleum product defined in 16A22C with on a wholesale basis for no such person business selling petroleum products defined in 16A22C with on a wholesale basis no such office manager shall discriminate the percentage supplied with the deliverer against independent retail oil delivery favor the dealers affiliated with the supplier. B. Any person with engaged in the business distributing, selling petroleum products defined in Section 16A22C on a wholesale basis with the intent to terminate the supply of the petroleum products defined in 16A22C through a retail dealership with given the written notice at least 14 days in advance for the termination of retail due with the municipality with the municipals in which retail dealers distribute the consumer and energy environmental protection concern with the proposed termination supply. Any person, firm, corporation who violates provision of the section shall be fined $1,000 for each violation. Or 16A22A, heating fuel dealers prohibited with the requirement of minimum dealer fines. Alright, no heating fuel dealer shall require violating with a regular consumer shall for the dealer except for the minimum delivery heating fuel of no less than 100 gallons and 75% of the primary tank size of which is less than condition of the delivery of such dealer. Alright, any heating fuel dealer who violates provisions of this section shall be fined with no more than $500 for each first offense, no more than $750 for the second offense occurring no more than 3 years of the prior offense, and no more than $1,500 for the third, or subsequent occurrence occurring not more than 3 years after a prior offense. 16A22B, surcharge price of fuel oil propane exemption, and that's been repealed. 1622C, the Registration of Petroleum Product Dealers Definition Regulations. Purpose of the Section 16A25, 16A to 15, 16A22C with the 16A22G, inclusive company meaning with a corporation, partnership, the proprietorship of any other business of the firm and a commercial entity. 2 petroleum products made with a middle distillated essential fuel oil, liquid petroleum gas, motor gasoline, aviation gas, aviation turbine fuel that define regulation consumer shall adopt the accordance with the provision, Chapter 254. Notwithstanding under the provision of the subdivision, contrary petroleum products shall not include gasoline other than aviation gas sold with the retail in accordance with the provision of Chapter 250 through the Commissioner of the Commissioner of Energy Environmental Protection of the Commissioner's designee. Or 16A22D, registration requirement affiliated companies. Any personally engaged with the wholesale, with the retail sale, both of the petroleum product in the state within the wholesale of the petroleum product, the consumption of the state with a shelf of at least 1 million gallons of such for the product annually with any person engaged with the operation of petroleum product terminal or petroleum product stop pipeline shall register with the commission no later than September 15th of each year with no later than 30 days of the commencing operation state with a such period which is later. Any person that gave the wholesale, retail sale of the both of the petroleum product and state with the wholesale of the petroleum product consumption with the state with the sale of at least 5,000 but less than 1 million gallons of such product annually shall register for the commissioner for the request of the commissioner, and not with more than 30 days after for the request. The commissioner shall not require the registration more than once in a 12-year period. 3. Such registration shall be on the form prescribed with the furnished for the commissioner shall require the registrant subject to the penalty of the false statement that under 53A, 157B, with the provided following information: A, the name of the mailing address, the telephone number of the registrant; B, the name of the mailing address, the telephone number of any of the company with which the registrant is affiliated, whether the affiliated company is engaged in wholesale or retail sale or both delivery and storage of petroleum products in the state with another state, both, whether the registrant engaged in wholesale operation, retail operation, both the delivery into or storage of the petroleum products, whether the registration engaged in the sale of the residents or customers, to any other name than place of the business used with the registration of the conduct business, any of the further information commission may be required pursuant to this title. For the purpose of this section, affiliated means existing one or more of the following relationship between the registered or any other company registered owned by whole and part with another company. 2. Registration has one or more common officer of the director of another company. 3. For the registered owner of facilities or the equipment common with another company. The registration engaged with the common operation joint ventures with another company. Registered control of the activities of another company. The activities of registration are controlled by another company. Or 16A22E, public listing of petroleum product. Commissioner shall maintain a public listing of personal engagement with the wholesale retail sale of the petroleum product for the registered in accordance with the Section 16A22D. Such publication listing shall include the information provided in accordance with Subdivision 1 and 3 of the subsection A of the said section. 16A22F, the annual report by Secretary has been repealed. 1622G, penalty failure to register. Any person failure to register for the September 13th of each of the year in accordance with 16A22G shall be deemed to have committed an infraction fine but not less than $75, except for the name of the person registered within 30 days, but they shall not deem the committed with the infraction light filing fee of $50 included within such person registration form. 16A22H, seller of the propane. Number 2, for the distillated fuels required to register regulations. Each person, firm, corporation required with the register pursuant to 16A22D with the cage of the wholesale of the retail sale of the propane within the state with the sale of at least 500,000 gallons of the product annually shall report with the Commissioner of Energy Environmental Protection upon the request of the Commissioner in such form with the prescribed by Commissioner in a low later than 15th day with each of the months with the Commissioner with the request of the report. Each such report state with the number of the gallons held within storage last day of the previous month for the location storage facility with the propane was stored with the number of the gallons propane had showed with the out of state with an estimate of the number of days showed with the representative of the gas hold. Gallons in storage. Any person and firm corporation engaged with the sale of the retail of the propane state with the report from the Commissioner with the request for the Commissioner of storage form of the prescribed for the consumer no later than the 15th of each month of the consumer requests a report. Such a report shall state with the number of the gallons of the propane sold with the other than retail during the provision of the calendar month, estimating the number of gallons to be sold during each of the calendar month. B1. Each person, firm, corporation required to register and pursuant to Section 16A 2258 from the wholesale of the retail, both sale of the O2 distillated fuel with the sale of excessive of 5 million gallons of such product annually to report the Consumer Energy Environmental Protection upon request of the Commissioner. Such form prescribed with the Commissioner no later than 15 days with each of the months which the Commissioner requested the report. So the request report shall have the number of the gallons stored the last day of the previous month, location each storage facility with the number 2 distillated was stored, number of the gallons per distillated fuel held with the shipment out of state with the estimated number of days sale supply represented by gallons held in storage in such report. Number 2, heating oil, diesel fuel shall be reported separately. 2, any other person, corporation engaged in the sale of the other than retail with the number of 2 distillated fuels in the state shall report with the consumer request for the Commissioner on such form as prescribed by the Commissioner no later than the 15th of each month for which the Commissioner requests a report shall report with the state of the number of the gallons 2 distillated fuel sold for the other retail during the previous calendar month, estimated the number of the gallons to be sold during the current month. Such report numbers of the 2 heating oil with the diesel fuel shall be reported separately. See, any person from corporation violates subsection A and B with this section shall be fined with no more than $100 for the first offense and no more than $500 for each subsequent offense. 2. The Commissioner of the Energy and Environmental Protection may adopt the regulation according with the provision Chapter 54 establishing reporting requirements of the petroleum product defined subdivision 2 of Section 16A22C. Alright, 16A22I, Commissioner of Energy with Environmental Protection authorized to obtain information concerning petroleum products. Notwithstanding any of the provision, general staff of the contrary with the Commissioner of Energy with Environmental Protection condition with the petroleum products market will require with additional sales inventory price with an information complete analysis such market Commissioner may require any person, firm, corporation engaged in sale, storage, and petroleum products in the state that provides such information concerning the petroleum products market as he directs. 16A22J, report sale, acquisition, change in current business practices. Each person, firm, corporation requires register pursuant to Section 16A22D shall notify the Consumer Energy Environmental Protection written within 30-day sale of the acquisition. Another person, firm, corporation registered with the pursuant said section charged with the current business practice of such person, firm, corporation used this section current business practice shall include state of the acquisition, petroleum storage, of the withdrawal of the entry of the petroleum product activity which would after alter information provided in the registration, most recent registration. 16A22K, unfair trade practices in business selling heating fuel lines. No heating fuel dealer shall condition the availability of the burner maintenance repair service upon the agreement ending with the consumer that purchasing heating fuel with the site of the dealer, provided the dealer may give the priority of the service to any of the consumer who has heating fuel delivery contract with such dealer. B. Any dealer who such heating fuel has established scheduled payment plans with the consumer shelf upon with the number determination heating of the fuel delivery return such consumer to 10 days of the receiving such notice. Any monies collected in excess of the retail price of the heating fuel actively delivered by the subsection shall not apply with the scheduled payment plan with the specific product unit is agreed in the length of the plan. See, each heating fuel delivery cell with the trade name heating fuel provided service of heating fuel burners shall disclose with the consumer, potential consumer the communication invoice with the advertising the name of the person in need with the file with the certified with the trade name as required by pursuant to section 35.1. Any violation of subsection A and 2C involved this section should be deemed unfair and deceptive trade practice under subsection 42.110B. Any heating fuel delivery who violates provision of this section shall be fined no more than $500 for the first offense, no more than $750 for the second offense, no more than 3 years after the prior offense, no more than $1,500 for the third subsequent offense occurring no more than 3 years after the prior offense. Alright, 16A22L, Fuel Conservation Energy Efficiency Program, Fuel Conservation Board, Fuel Conservation Plan has been repealed. Alright, 16A22M, Residential Propane Service Termination. No propane supplier shall terminate the service with no repayment of the eligible residential propane customer living at the location served with a 10 or more vapor meter for the consensual heating profit purpose of the Friday, Saturday, Sunday legal holiday with the legal holiday less than 1 hour from such propane supplier's office closure for the day without the 14th the day with the written notice of the pending determination, include with the day of the determination, state with the steps of the consumer, with the take of the reinstate service of the resident, with the customer, of the owner, with the record of the customer who provide with the documentation that have applied with the energy assistance between November service and May 1st of the propane supplier may collect with the financial charge of the pace due with the balance of not exceeding 1.5% of the per month of the propane supply with determined the dangerous condition exists. Such propane supply may terminate any service at any time without notice. B. As given in section eligible residential propane customer, with the residential propane customer A who received the local, state, with the federal public assistance with the whole source of the financial support, security, Social Security, United States with the Department of Veteran Affairs with unemployment compensation benefits. C. Who is heard with a household that is unemployed with a household income is less than 300% of the poverty level determined by the federal government. D. Who is seriously ill, who has a household member who is seriously ill, who income falls below 200% with the poverty level determined by the federal government. Whose circumstance with the threatened deprivation of food, with the necessity of life, with the human dependent, with the children payment of the delinquent bill, with is required to a household income with the combined income over the 12-month period with the customer and all of the adults except for the children of the customer who have been members of the household for 6 months or more. For 16A 22M Fuel Oil Conservation Board and the Established Fuel Oil Conservation Board consists of the following: member of the Commissioner of Energy and Environmental Protection, his or her is designed shall have the chairperson of the board convening with the meeting, the representative of the retail oil heater, appointed presidential pro tempore of the Senate, representative of the heating, ventilation, air conditioning, and trade, the license of the Chapter 393 with the agreement with the implementing energy efficiency systems, and appointed with the Speaker of the House, representative of the wholesale heating distributor operating in the state with appointed with the majority leader of the Senate. 5. The state of the biodiesel distributor appointed with the minority leader of the Senate. 6. A representative of the statewide environmental advocacy group with the expertise with the energy efficiency measure for the appointed with the major leader of the House, representative of the 7th retail oil dealer experience with the implementing energy conservation service appointed with the minority leader of House of Representatives. And 8. The 5 public members of the public appointed by the governor, one of whom represent the environmental organization knowledgeable with the energy efficiency program, one of whom represent the consumer with the advocacy organization, with the representative of the business community, one of whom shall be the representative of the low-income rate players, and one of whom shall be the representative of the state resident in general. And all appointed members of the board shall serve in accordance with section 41A. The Fuel Oil Conservation Board, if established pursuant to the section of the shall be a successor Fuel Oil Conservation Board, established pursuant to section 16A 22 in the General Statute provision 1958, revised January 1st, 2011. All appointment of Fuel Oil Conservation Board should be no later than 30 days after the October 27th, 2011. Each appointing authority shall provide the consumer energy environmental protection with the name of the contact information to each of the appointed board member. Fuel oil conservation shall be within the Department of Energy and Environmental Protection for the administrative purposes only. Fuel oil conservation board shall be responsible for the administration of energy efficiency fuel oil furnace boiler replacement upgrade repair program established pursuant to subsection 16A 46J. Or 16A 23 gasoline supplied with the franchise to independent distributed equal treatment and enforcement. No person gave with the business with the refined petroleum and gasoline furnished gasoline with the retail distributor of the gasoline subject to the sale with the public in the state with the shall fail with the further gasoline independent retail distributor gasoline within the state with the whether or not franchise by such a person the wholesale place for the price of the reasonable quantity for this line with he continue to furnish gasoline to the retail distributors of the gasoline in the state which are wholly owned by him and the operated under the franchise granted by him. It shall constitute the prima facie of the violation provision of subsection A of the section of any such person one during any of the calendar month beginning after July 1st, 1973 to deliver independent retail distributor of the gasoline in the state with a percentage of the total gasoline delivered by him in a retail distributor gasoline with the state with the during the month of which the lower percentage of the total gasoline delivered with him with the retail distributor of the gasoline state during the period of July 1st, 1971 to June 30th, 1972, was delivered by him an independent retail distributor gasoline stating the period during period 2 for the gasoline with independent retail distributor for the gasoline stay with the price during any such months with greater than A, the average price at which is sold with the gasoline such distributor during period from July 1st, 1971 to June 30th, 1972 increased by B by the percentage equal to the percentage average price of the gasoline sold during the month with the retail distributor of gasoline which are only operative the operated on franchise guaranteed with the Pearson exceed with the average price of the gasoline sold with the sold was distributed during the period of July 1st, 1971, June 30th, 1972. A violation provision subsection A of the section constitute unfair trade practice with the provision of Chapter 173.5a. Or 16A, 23A, sale of anthracite, regulations enforcement. The Commissioner of the Consumer shall adopt the regulation according to the provision of Chapter 54A of the defining standard of the substandard of the anthracite based on the specification underside of the ash and slave of the bone content that will require any of the person, firm, corporation selling anthracite either with one from out of state with a resale with the state with or two with within the state only to provide written notification of the purchaser to whether the anthracite is standard or substandard of the defined in such regulation. Regulation shall deem unfair, deceptive trade practice on subsection A, section 42.110b. Alright, and that covers Title 16A, Planning Energy Policy, Chapter 296, Operation Fuel Supply Business.